Welcome to video 5 of the International Commission of Jurists course on litigation before UN human rights treaty bodies. Today we'll examine what measures are available from the treaty bodies to prevent irreparable harm and for the protection of clients and others at risk of such harm. As far as the Human Rights Committee is concerned, this is provided for in Rules 94 and 95 of the Rules of Procedure of the Committee, and you find similar provisions in the rules of most other committees. Human rights cases, such as those submitted to the human rights treaty bodies, frequently include a significant risk for victims and those supporting them in their quest for justice. We've heard in the first video that complaints cannot be submitted anonymously and that the state will always be informed about the identity of the victim. As the very nature of human rights violations means that the state was implicated, if not directly responsible for them, these cases are naturally sensitive. So victim safety should be a key concern, and how to respond to any potential risk should be part and parcel of any litigation strategy. Most treaty bodies provide for special procedures designed to respond to threats and risks. These include the treaty bodies requesting that a state party take so-called interim or provisional measures to refrain from taking certain actions in order to avoid irreparable harm to the victim while the treaty body is considering the complaint. The two most common scenarios when treaty bodies request state parties to implement interim measures are first, when the state has decided to deport an individual to a country where they claim they face a foreseeable risk of torture or ill treatment, and second, when an individual is on death row facing execution before consideration of his complaint by the treaty body. In such cases, the state parties are usually requested to refrain from taking any action while the treaty body is considering the complaint. In other instances, the Human Rights Committee has requested a state party to provide adequate medical assistance to a detainee or to take measures to protect individuals who had received threats while seeking a remedy. In a case filed against Libya, where the victim had been held in incommunicado detention for several long periods over 13 years, and where his family had not known about his well-being or his whereabouts for some months, the committee requested the state of Libya to adopt all necessary measures to protect the life, safety and personal integrity of Mr. Ben Ali so as to avoid irreparable damage to him. Treaty bodies may also request state parties to adopt specific measures of protection where complainants, their families or their legal representatives are threatened, intimidated or actually suffer reprisals because they filed a complaint with the treaty body. The body may then, for instance, request the state to take specific measures and seek clarification from the state and request explanations about any actions taken in response. As litigants, we can ask the treaty body for interim or for protection measures at any moment of the proceedings. Contrary to interim measures, which are only available during the proceedings themselves, measures of protection can be requested also during the implementation phase of a treaty body's decision, for instance, where a risk of reprisals occurs in the context of implementation. Often, filing the complaint and the request for interim and protection measures go hand in hand. The committee's standardized complaint form provides for that opportunity. If you do not use the form, you should either expressly include the request in the complaint or submit it together with the complaint but as a separate document explaining in detail the reasons why you request such measures. It may also help to provide the treaty body with some context of the situation and to highlight potential measures the state should take that may help prevent irreparable harm and to identify the authorities in the respondent state who should be responsible for implementing interim measures. This could then support the treaty body in formulating a specific, detailed request for interim measures and protection measures and help them direct it to the authorities in charge. Treaty bodies may request the state party to adopt interim measures on their own initiative if they are concerned for a victim's well-being or upon the request from the victim or their representative. In deciding whether to request such measures, the treaty body will consider the imminence of the threat to the victim, So this requires the complainant or their representative to demonstrate that the risk is real and personal rather than based on a general context. So where you request specific protection measures for the victim, their close family, or even yourself as the legal representative, you must show that there are well-founded indications that the filing of the complaint to the committee has or will result in acts of intimidation against those persons. For interim measures to be granted, you must also show that the consequences of the threatened action or omission by the state would be irreparable, that is, of such nature that it cannot be reversed and cannot be remedied. The Human Rights Committee, for example, considers that interim measures are typically related to potential violations of the right to life, the prohibition of torture and ill treatment, but it has also granted interim measures to stop imminent violations of other rights, such as the right to privacy, to freedom of thought and religion, and to freedom of opinion. It can take several days for the treaty body to consider a request for interim measures or measures of protection. Some committees, like the Human Rights Committee, have appointed one of its members as the special rapporteur in charge of interim measures. Where the special rapporteur is in doubt as to the imminence or irreparability of harm, they can also grant provisional interim measures, providing the state party with an opportunity to provide further information about the situation. The complainant then has an opportunity to comment on any state observation in this respect, and the special rapporteur will then take a decision whether or not to lift the request for interim or protection measures. Where the request is granted, the treaty body will issue and share its interim request with the state party and inform the complainant. As the legal representative of the complainant, it will be important to regularly update the relevant treaty body about the situation and to bring any concerns about non-compliance with the measures immediately to the attention of the treaty body. What happens in cases of non-compliance? So where the state party does not comply with the requested interim measures, it will be in breach of its obligations under the protocol and may also be in violation of the treaty itself. This is because treaty bodies consider interim and protection measure requests as binding on state parties, as something that cannot be separated from the treaty and the recognition of the competence of the treaty bodies to examine individual cases. Additional measures of protection the treaty bodies may take is to refrain from publishing the name of the victim and their representative and any identifying criteria in the decision, as decisions are made public as already mentioned. The treaty body will usually expressly ask you if there are any concerns about publicizing the name of the victim. However, if you have such concerns, it is best to make that clear as soon as submitting the complaint and reiterating this in the correspondence with the treaty body. This measure is limited to not disclosing the identity to the public, but again, the identity of the complainants will always be disclosed to the respondent state. As we could see, the treaty bodies are relatively limited in what they can do to ensure the safety of a complainant, their family, and lawyers from reprisals, beyond requesting the state to cooperate and comply with any such measures ordered by the committee. This is particularly limited when the threat emanates from the state itself. Treaty bodies cannot provide direct protection. Where imminent risks of reprisals exist at the outset of a complaint or occur during the litigation process, additional measures of protection, such as temporary or longer-term relocation, may need to be considered by the complainants and their legal representatives themselves. However, the committee bodies will not help with that. You may also consider not filing the case for the time being and waiting for the situation to improve. Such delays can always be explained to the relevant committee when submitting a complaint at a later stage. It is important to clearly explain to the victim the limitations of the committee's ability to intervene, as this has also an impact on their informed consent about whether or not to file a complaint with the treaty body. This brings me to the end of this lecture. In the next video, we'll look at the requests for a remedy and reparation. I hope to see you there.